Welcome to the Earth Chronicles. Tonight's presentation is on COVID-19 emergency powers. In December 2019, a new coronavirus was detected in Wuhan, China, causing outbreaks of the virus that has since spread across the world. On January 31st, 2020, in response to COVID-19, the Secretary of Health and Human Services declared a public health emergency under Section 319 of the Public Health Service Act, which is a legal statute.
Trump has been clear. His top priority is the safety of the American people. In addition to the steps that the doctors have outlined, we continue to operationalize a multi-layered, cross-agency public health response. Following the World Health Organization's decision to declare the 2019 novel coronavirus a public health emergency of international concern, I have today declared that the coronavirus presents a public health emergency in the United States.
President Trump then suspended entry of foreign nationals into the United States who had been in jurisdictions where COVID-19 outbreaks had occurred within the past 14 days. Including China, Iran, and parts of Europe. The administration instituted quarantines for individuals evacuated from foreign nations pursuant to the Public Health Service Act. On March 11, 2020, the World Health Organization announced that the COVID-19 outbreak was now a pandemic, as the rates of infection continued to rise in many locations around the world and across the United States. The virus seems to have spread from China and surrounding areas to Iran and from Iran into Europe, most specifically Italy. The president responded by declaring a national emergency. Quote, "Now therefore I, Donald J. Trump, President of the United States, by the authority vested in me by the Constitution and the laws of the United States of America, do hereby find and proclaim that the COVID-19 outbreak in the United States constitutes a national emergency, beginning March 1st, 2020. Pursuant to this declaration, I direct as follows." End of quote. He then goes on to make a number of directions to his cabinet, etc. They need not concern us now. The most important point to be made here is where the president is getting the authority to proclaim a national emergency from. Notice in the opening line he states, quote, "By the authority vested in me by the Constitution and the laws of the United States of America," end of quote. So he claims the authority or powers come from the Constitution and the laws of the United States, two different and important sources. To reiterate, there are two sources of authority used to proclaim the emergency: the laws of the United States and the Constitution. Title II, Declarations of Future National Emergencies, Section 201 states, with respect to acts of Congress authorizing the exercise during the period of a national emergency of any special or extraordinary power, the President is authorized to declare such a national emergency. Such proclamation shall immediately be transmitted to the Congress and published in the Federal Register. So we see that Congress, being the maker of all law, authorizes the use thereof. Thus, there are limits and restraints upon the President in his exercise of emergency powers. The Constitution makes no allowance for the suspension of any of its provisions during a national emergency. Disputes over the constitutionality or legality of the exercise of emergency powers are judicially reviewable. Both the judiciary and Congress, as co-equal branches, can restrain the executive regarding emergency powers. U.S. Code Title III, Exercise of Emergency Powers and Authorities, Section 301 states, When the President declares a national emergency, no powers or authorities made available by statute for use in the event of an emergency shall be exercised unless and until the President specifies the provisions of law under which he proposes that he or other officers will act. Such specification may be made either in the declaration of a national emergency or by one or more contemporaneous or subsequent executive orders published in the Federal Register and transmitted to the U.S. Congress. We note that Article 6, Clause 2 of the Constitution states, quote, that the Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. End of quote. Notice the article begins by saying, quote, this Constitution and the laws of the United States which shall be made in pursuance thereof are the supreme law of the land, end of quote. The supreme law of the land is composed of the Constitution and the laws of the land made in pursuance thereof. The Constitution existed before the laws of the land or the supreme law of the land were made. The Constitution not only comes before the laws of the land, those laws must be in pursuance of the Constitution. They must follow the dictates of the Constitution, or they are not laws. They are not bad law, they are not law. Ab initio. As Supreme Court Justice Marshall stated in Marbury v. Madison, quote, it is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but only those which shall be made in pursuance of the Constitution have that rank. A law repugnant to the Constitution is null and void. It carries nor force of law. End of quote. In other words, just because the legislature passes a law, it does not mean it's sacrosanct. It must be in pursuance of the Constitution, or it is null and void. It has no binding power or authority. Ab initio. President Roosevelt was a huge proponent of national emergencies and the laws and statutes arising therefrom. He stole many rights from the people by proclamation. It was Roosevelt who called in and stole the people's gold. Taft, who came after President Roosevelt, responded by saying, quote, the wide field of action that this would give to the executive one can hardly limit. A president can exercise no power which cannot fairly and reasonably be traced to some specific grant of power, end of quote. And he cautioned that, quote, such specific grants must be either in the federal Constitution or in an act of Congress passed in pursuance thereof. There is no undefined residuum of power which he can exercise because it seems to him to be in the public interest, end of quote. We agree with Taft. However, President Taft is not the only authority that has weighed in on this matter. In the Supreme Court case of Home Building and Loan Association versus Blaisdell, Chief Justice Hughes stated the following, quote, emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon power granted or reserved. The Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were determined in light of the emergency, and they are not altered by emergency, end of quote. This case was heard in 1933 in the depths of the Great Depression, which is about as serious as it gets. Thus, the power to declare an emergency is not as cut and dried as some would have it be. In fact, there are legal considerations whether the president or state governors have the power to close businesses down, order people to stay at home, and mandate other actions to promote the public health. The national and state governments have varying powers to take actions to promote public health and safety, but those powers are limited even in emergencies, and an emergency does not create new powers. The national government cannot order mandatory vaccines or quarantines or shelter-in-place orders without violating one of several clauses of the Constitution. The most critical circumstance here is in regard to mandatory vaccines, especially if they are to be regulated by chip implants. Already there is talk about different ways that one can prove they have been vaccinated. It is these types of mandates that should not be blindly agreed to by the public. Today, we cannot go out without masks. What might it be next year? We, the people, only have the rights we stand up for.